Got it, sir. Thank you, sir. Good evening, Your Lordship, Your Ladyship, and learned councils. Welcome to the 6th TGA Virtual Moot Court Competition. My name is Snigdha, and I will be acting as the court master for this session. It is my distinct honor to welcome our esteemed judges, Advocate P.C. Nirmala Ma'am and Advocate Manav Gessel Thomas, sir. Advocate P.C. Nirmala Ma'am is a senior member at Office of Thomas George and Associates. P.C. Nirmala Ma'am hails from Hyderabad and did all of her formal education in Hyderabad. The driving force behind the firm, who held various positions including lecturer, associate professor, head of department, academic dean, and controller of examinations with a background in science under the UGC, retired from the reputed women's college, St. Francis College for Women, after 35 years of unwavering dedication. After completing her schooling at the prestigious St. Anne's High School, she went on to earn a BSc from St. Francis College for Women, Begumpet, and furthered her education with a master's degree from Usmania University. Following her post-graduation, she joined St. Francis College for Women as a lecturer and has held many high-level positions, as mentioned. While at St. Francis, she also founded a nature club, Prakriti, which has had great success and remains a significant part of the college. Post retirement, she decided to start a new chapter by joining the field of law full time. She intends to utilize the training to cater to the needs of the society by uplifting the downtrodden and underprivileged, promoting environmental awareness, Prakriti, and empowering women. She currently represents the firm in matters before the Honorable Supreme Court, Honorable High Court, debt recovery tribunals, consumer courts, family courts, and civil and criminal courts. Thank you, ma'am, for lending us your time. Advocate Manav Gessel Thomas, sir, is a senior member at Thomas George and Associates and is a budding lawyer. He joined the firm right after graduation from ILS College, Pune in 2015. His area of work encompasses litigation in various areas, including civil, criminal, labor, administrative, banking, personal, and business law, as well as assisting in handling non litigation matters for the firm. Mr. Manav has been handling litigation matters before various forums, including the High Court of Telangana and Andhra Pradesh, district courts, and other statutory tribunals and quasi forums. Over a short span of 2 years, he has received accolades from honorable judges for well-researched presentation of cases at hand. Apart from his passion for advocacy, Mr. Manav is also dedicated to serving society and has volunteered at Make a Difference, MAD, an NGO that empowers children from economically disadvantaged backgrounds by providing them with quality education. We thank you, ma'am and sir, for your valuable time and efforts in adjudicating this session.
Thank you so much.
Thank you, sir. Before we proceed, I request all participants to ensure that they have stable internet connection. Please keep your cameras turned on throughout the proceedings. If you experience any technical glitches or connectivity issues, strictly communicate this via the chat box immediately. In the event of a disconnection due to bad internet connectivity, a maximum extension of 5 minutes will be granted to the affected speaker to reconnect. With the permission of the bench, may I please proceed to outline the rules of the competition?
Yes, you may proceed.
Much obliged. Thank you. The structure of the proceedings will be as follows. Counsel 1 and Counsel 2 for the appellant will present their case, followed by Counsel 1 and Counsel 2 for the respondent. Each speaker is allotted a total of 15 minutes. Any extension beyond this time is subject solely to the discretion of the bench. I humbly request the bench not to grant any extension of time due to a fixed schedule. As court master, I will be strictly monitoring the watch. Screen sharing of judgments or documents is permitted only with prior permission from the bench. The court is in session now. Over to the teams. Thank you.
Yes, firstly, TGA 12, are you all going to be the appellant in this case?
Certainly, Your Lordship.
Okay, please don't narrate the facts, just directly go on to your arguments.
Certainly, Your Lordship. May it please this Honorable Court, this the Council appearing on behalf of the appellant in the present matter. Before the Council goes ahead, if it is of no inconvenience to Her Ladyship, may the Council collectively address the bench as Your Lordships.
I leave that to my lady to agree.
No problem.
Certainly, much obliged, Your Ladyship. Your Lordships, in the present case, there are
Before you
four.
move on, I understand that this is a civil appeal filed before the Supreme Court. So, under what provision of the Constitution or NCLT rules, how have you approached the Supreme Court?
Your Lordship, we have approached this court via Section 62 of the IBC. However, we also understand that civil appellate jurisdiction is also provided in the Constitution under Article 132. However,
132. So you're reading your appeal is filed under both the provisions of law because your memorial only refers to one provision.
Your Lordship, 62 directly grants the power to approach the Supreme Court, Your Lordships. Therefore, we did not refer to the constitutional provision.
I see. Okay. So is there any other alternative remedy other than approaching the Supreme Court in this particular matter? Is there any other remedy that you could exhaust before filing this civil appeal?
Your Lordship, there wasn't any other remedy, Your Lordships, as we already had the petition dismissed by the NCLAT.
We understand that you're the bank who lost the matter before NCLT and NCLAT. So if there was a glaring irregularity or illegality in an order, you could have approached the High Court in a writ jurisdiction if there is a glaring error. Why trouble this court?
Your Lordships, primarily as two courts have already adjudicated this matter.
Is NCLAT not within the bounds of jurisdiction of a High Court? Are you saying it is not?
Your Lordships, the provision under 62 does not mandate us to approach the High Court.
That's the regular route. Okay. The simple question is, does the High Court not have supervisory jurisdiction over this NCLAT decision? Does it or does it not?
It will not, Your Lordship.
It will not? Okay. Do you have any case law or any law to support what you're saying? Because that's completely erroneous what you speak.
Your Lordship, I apologize for the error. The High Court does have the jurisdiction. However, it is not a mandatory route that the bank ought to have taken. And the provision under 62 being available to the appellant is what the appellant chose to.
Okay, so you're saying there are multiple remedies now. From no alternative remedy, you have come to a stand that there are more than one remedies.
Your Lordships, it is the discretion of the party to approach the remedies available to them, which is
Please
why
proceed. Please
much
proceed to
obliged.
your argument.
Your Lordship, the present counsel will be dealing with the first two issues at hand, followed by my co-counsel who will be dealing with the third and the fourth issue. Your Lordships, the first issue at hand is whether or not a second application under Section 7 of the IBC is barred by law. It is the most humble contention of the appellants that it is not barred by law. And to elaborate on the same, this counsel would like to put forth before this court three broad arguments. The first one, Your Lordships, being the applicability of res judicata in the present case. Your Lordships, the appellant would like to submit that considering the fact that the first Section 7 application was solely dismissed, firstly under Section 10A, we understand, Your Lordships, that the NCLAT later decided on merits. However, Your Lordships, the merits again were stemmed to the fraudulent date of default that was submitted before the first application.
Counsel, are you aware of clarification 12 of your moot proposition? It clearly says that it was dismissed for any reason, either on merits or for a technical error. So if it is dismissed on merits, how is the principle of res judicata not applicable to you?
Your Lordships, that the reasoning being that the first application did not properly consider that the
So
NPA
are you
was.
trying to tell me everyone will first lose a big round of litigation from the NCLT till the Supreme Court, learn what all mistakes they do, and then again file fresh applications. Then there will be no end to litigation in this country. Are you
Uh,
aware of the number of cases pending before this court that you want to come with these frivolous second time litigations? Then you learn something new today, then you will apply in the third application.
Certainly not, Your Lordship. Your Lordships, we understand that there was a technical irregularity in the first application. However, Your
Your
Lordship,
admission is enough. Your admission is enough to dismiss this appeal. There's no need to hear anything more.
your but Your Lordships, even the facts are clear when they say that one of the one of the core reasons as to why those applications were dismissed was on the ground that they fell within the COVID-19
Is the loan
moratorium.
transaction different in this case? It's the same as the first application. Am I correct?
Certainly, Your Lordship.
Is the date of NPA in the previous date and today the same? The date of NPA, has that changed? No.
Your
Date of
Lordships, the
NPA,
date of
not date of default. Please listen. Date of NPA, is it the same? Yes. Loan outstanding is the same? Yes. Then borrower is the same? Yes. Bank is the same. What else do you want to do?
Your Lordships, but if previous courts have not properly appreciated the facts, Your Lordships, there is a provision, there are multiple case laws that where authorities that
Please show an authority where the principle of res judicata is not applicable to this case.
your,
Directly
your,
go
Lord-
to the case law.
Your Lordships, I did not mean to say that they've applied res judicata. What this council was trying to elucidate,
Is there a case law which supposed issue one for you? Is there any case law to support you?
certainly, Your Lordship.
Which is that?
Uh,
Because NCLT Mumbai's judgment is completely against you.
Your Lordships, the proposition that this council wants to put forth before this court is that there
We
always
understand your proposition. Do you have a case law to support your proposition? Simple.
certainly, Your Lordships, the uh, the NCLT of New Delhi in the case of Puneet Bhatia versus ASREC,
That only
something
speaks about changing the date of default and permitting amendments to be given to dates of default. It nowhere
certainly
speaks about a second application for the very same facts. Puneet Bhatia is completely not applicable and it's not an NCLT judgment. It's an NCLAT judgment.
an NCLAT judgment.
Don't
Certainly,
mislead this court.
Your
Read the
Lordship,
correct case law. It's a
yes,
three-bench decision of NCLAT, not NCLT.
yes, Your Lordships, it's an NCLAT judgment. What this council wants to put forth is that the authority is empowered to order for such amendments if there are irregularities in dates.
Did
The
you
same,
ask for that in the first time, in the first
your,
round of
your
litigation?
Lordships, the authority has the power to request. If the authority feels like the date
It's
that
an
the
option. You read the Puneet Bhatia's judgment, para 26, 27. What does it say? Authority may tell financial creditors to correct the date of default. The word used is may, not shall. So when the courts have the power, they don't have a mandatory power to tell you what to do, right? It is your duty what to do. So Puneet Bhatia is not applicable on res judicata. Do you have any case law on res judicata?
Certainly, Your Lordships, even in the case of Innovative Industries versus ICIC Bank,
That also is not on principle of res judicata, no counsel. Is it on res judicata?
Your
In
Lordships, this council seeks to establish the principle of res judicata before this court by
Madam,
under.
your voice is not audible.
Am I audible now, Your Lordship?
No, no, madam, my co-judge.
Now I'm audible.
Yes, ma'am, you're audible now.
Kindly show the citation, ma'am.
Certainly, of the Innovative Industries judgment, Your Ladyship. With your permission, may my researcher please screen share the judgment?
Yes, yes, you can screen
The,
share, but innovative is again. Yes, madam, you're saying something?
the relevant para.
Paragraph number 30 of the judgment, Your Ladyship.
Please understand, we'll not be giving extension of time for all this waste of time, counsel. Counsel, please understand this innovative judgment which you're relying on is not on res judicata. Am I correct?
Certainly, Your Ladyship, Your Lordship, the point that the council is trying to make is that when there were irregularities or when there were unappreciated evidences in the first petition, therefore the appellant coming now under a second application will not be completely barred by res judicata.
Counsel, understand the provision of law. If you're right or wrong, you can stop share screen. if you're right or wrong in any particular case, you have a appellate jurisdiction. From an appellate jurisdiction, you have the Supreme Court. You chose not to file a civil appeal on the previous occasion. You're right or wrong in whatever you did. Today, you can't come with the same facts with another case. You please give a case law where there is a second application filed under Section 7 for the very same issue. Is there any case law till today on this point? CPC might have case laws, but you should bring it to our notice. We should be enlightened by you, right, counsel?
Certainly, Your Lordship, if I may cite the NCLAT order in Deshbhushan Jain versus Abhay Kumar, where a new cause of action or a new default let the court administer a second application because they believed a fresh cause of action had arisen.
Your case is again different. You see your paras 4 of your fact sheet. There is a table of OTS letters. OTS letters did not change because when you filed the application on 1/2/2022, is there any OTS letter after that particular date? No. So facts are again, there's no new date of default. How is that case law helping you?
Your Lordships, every acknowledgement letter stretches, it does not create a fresh cause of action.
Exactly. So before when, what was the date of filing your previous NCLT application? Please tell us.
It was in 2022, Your Lordship.
Was it in 22?
2020. It was
Please
in
give the date.
2020, Your Lordship.
2022. Right? 1/2/22 was your first application. When did you file your second application?
In 2024, Your Lordship.
2024. From 2022 to 24, is there any other OTS letter in your facts?
Certainly not, Your Lordship.
No. Then there is no change in facts. Your case law does not apply to you. Please move on to the next issue. We are not convinced on this application not being maintainable. We are thoroughly not convinced. Yes, second issue.
Much obliged, Your Lordships. I would like to address it in the end if I have the time. On the
We'll
second
look into
issue,
it.
on the second issue, Your Lordships, on whether or not mentioning of dates of default is mandatory under applications under the IBC, this council would like to put light firstly on the non-mandatory nature of the date of specification in Form 1. Your Lordships, we understand that Form 1 requires the date of default.
To understand, if you understand, then you should not argue that it's not required.
Your Lordships, we are not undermining the importance of the date of default. All this council would like to put forth before this court is that it's not mandatory. And to elaborate on the same, Your Lordships,
Case law, please.
The case of Geocon Infra versus Bridge Gopal, Your Lordships, the NCLT New Delhi.
NCLT judgment is not binding on the Supreme Court. I hope you're aware.
Certainly, Your Lordships, even NCLAT judgments, they are persuasive, and we hope Your Lordships are persuaded by the same. In para 22, Your Lordships, if my researcher can screen share the judgment, it says that the default occurred, and thus we assume the date of default in the present matter to be 12/1/2022. Hence, we observe that non-mentioning of the date of default does not affect the merits of the present case. Further, Your Lordships, even in the case of TLG India Private Limited versus Puranic Builders Limited.
No, in that particular case, are you telling that in this case that you're sharing the screen, you're telling that there was no date of default mentioned, you're saying?
Certainly, Your Lordships, paragraph 5, clause 2, if I may read out as my
Has not
researcher
been
has.
specifically mentioned. Okay, we can understand. But if it is the demand notice, this is applicable to a Section 9 case. We are before a Section 7, right? This is not a bank matter.
Certainly, Your Lordships, but the relevance.
No. Section 9 case laws will never be relevant to Section 7 matters. Never. There's a complete difference in the whole analogy. Is a Section 7 mandating issuance of a prior notice? Does it mandate? Counsel.
No, Your Lordship.
You all cannot be questioning ChatGPT when we can see, at least while sharing your screen. At least be a little smart and not put my question in ChatGPT. Researcher, please use your intellectual differentia not so poorly. I think you should stop sharing your screen. Yes. Yes, counsel, continue.
Your
I don't think
Lordship,
ChatGPT can give answers always. Yes, move on.
Your Lordships, there's also the judgment. I believe I've completed my time. May I ask for an extension of a minute, Your Lordship?
No.
Thank you, counsel.
Thank you.
It was a pleasure arguing before this court, Your Lordship.
Thank you. Thank you.
We'll take a short brief break of 30 seconds, ma'am. 30
Yeah.
seconds to 2 minutes and then commence the second person. Thank you. Ma'am, you can mute yourself. Ma'am, shall we start counsel 2 from the appellant side?
Yes.
Yes, counsel 2.
May it please this honorable court, this is counsel 2 for the appellants, and I will be dealing with issues 3 and 4. With the
Yes.
permission of the bench, I would like to go on to issue 3.
All permissions granted. Please only argue.
Much obliged, Your Lordship. Issue 3 is whether or not the date of default changes based on facts and circumstances, or whether it is to be taken as the date of NPA in all banking matters. Your
Counsel, what
Lordship,
do we mean by NPA?
NPA is non performing assets, Your Lordship.
So, how is an account classified as an NPA?
Once the corporate debtor makes a default, and the 90 days after, the same asset is classified as a non-performing asset or a bad debt in the bank's account, Your Lordship.
So, it's a 90-day period, there's a default, and after 90 days, they classify as NPA. What happens
Yes,
before NPA? What is that classification called?
date of default, Your Lordship.
No, I'm saying prior to 90 days, there are two more classifications. What are they? Are you aware?
I am not aware, Your Lordship.
Please move on. Proceed.
Firstly, Your Lordship, the definition of default under the IBC is independent of the NPA classification. Under Section 3, subsection 12 of the Insolvency and Bankruptcy Code 2016, default is defined as non-payment of debt when whole or any part of the amount has become due and payable but has not been paid. Therefore, the statutory trigger for insolvency is the factual non-payment and not the date on which the loan was classified as NPA under RBI regulation. The NPA label is only an accounting
Counsel, please
consequence that occurs
understand.
90.
Counsel, please understand. Your entire case is going to support you if you are going to argue that in your case, the NPA date should be reckoned as the date of default. I don't know why are you arguing otherwise. Isn't it going to help you if you argue that the NPA date should be the date of default in your matter? Isn't that your strategy or stand?
Your Lordship, our contention is that the date of default does change according to the facts and circumstances.
Then why have you mentioned date of default as the date of NPA in your case at para 10 of your fact sheet? Do you know what is para 10 of your fact sheet?
Your
I'll,
Lordship, if you give me a minute.
I'll read it for your convenience. Thereafter, the financial creditor filed another Section 7 application on 1/1/2024 before the Honorable National Company Law Tribunal against the same corporate debtor by mentioning the date of default as the date of NPA, that is 1/4/14. So isn't that your argument? Though there are changes in the date of default, if you're arguing, why did you choose NPA date as date of default?
Your Lordship, the council here is trying to say that the date of default do change based on facts and circumstances and is not to be taken as the NPA date. Since it's a continuing,
I agree with what you're saying. In fact, I believe that the date of default changes. I very well concede to that. This bench is agreeing to it. Why have you not mentioned the date of default as uh, 1/1/22 as per para 4.9 in the table? Why did you not choose the last OTS letter as date of default? Why have you mentioned NPA date as date of default and you're arguing otherwise? Do you know
the very
OTS
initial,
letters? Have you seen the
yes,
OTS letters? Have you seen the last date of the OTS letter? You know what it is?
according to the fact sheet,
According to fact sheet, yes. What's the last date of OTS?
the 1/1/2022, Your Lordship.
Correct. Now you are saying that date of default shifts as per facts and circumstances. Very well, we agree with you. Why do you write date of NPA as date of default as per para 10?
Your Lordship, the default continues after the date of default and in the 90 period time also, the same date applies that as the default continues.
Okay, please proceed.
Much obliged, Your Lordship. In Innovative Industries Limited versus ICICI Bank Limited, the Honorable Supreme Court has held in para 27 that the scheme of the code is to ensure when a default take place in a sense that a debt becomes due and is not paid. And that is when the insolvency resolution process begins. Default is defined in Section 3, Clause 12 in very wide terms as meaning non payment of a debt once it becomes due and payable. Hence, in the IBC, the date of default is a matter of fact. Secondly, Your Lordship, the date of default may vary with acknowledgements, part payments, or restructuring. Date of default here may shift with subsequent acknowledgements, and the same renews the liability, Your Lordship.
So
In the
is it
case
not
of
a case that the date of default remains the same, but the limitation period extends? Shouldn't that be the correct interpretation? Date of default will be one, but these OTS letters would extend your timeline. Shouldn't that be the right? That means
absolutely, Your Lordships,
the date of default doesn't shift. It is
it does
only
not shift, Your Lord.
doesn't shift. Okay, please go on to your fourth issue.
Much obliged, Your Lordship. Fourth issue is whether a case can be admitted if a default has occurred and the application is within limitation despite an error in the date of default. Your Lordships, the appellant submits that once default and limitation compliance are established, an application under Section 7 cannot be rejected merely because the date of default was mistakenly mentioned. Firstly, Section 7 of the IBC makes it abundantly clear that the existence of default and limitation compliance are the very primary tests for admission of
But
application.
NCLT rules also tell that if the application is incomplete, then the case can be rejected by the authority. So if your date of default is wrong, it does not mean that you cannot dismiss. Is the word may used or shall used in the? Yes, ma'am.
May, Your Lordship.
May.
I have a question now. Like when you have mentioned the date of default, as per Section 7, there are so many details of the default which is required. And in the details of the default, was not the date of default asked as per Form 1?
It is not a mandatory field in Form 1, ma'am.
Are you sure?
Yes, Your Lordship.
Have you
How
read?
do you how do you say it's not mandatory?
Can you show that it is not mandatory? Can you show Form 1?
If my researcher could screen share Form 1 for the bench's convenience.
No, no, counsel. We are not asking you to share the format of the law. We are asking you where is it written in the law that it is not mandatory. You're saying it's not mandatory. Where is it written? Simple. That's what my
My
co-judge is asking.
my question is also that when you have furnished all the details of the default, was not the date of the default also required to be mentioned?
Yes, it was mentioned. In the very first application, the mentioned date was 2020, and in the subsequent application, the date of default was the initial date of default, which was the 2014 date.
So you have changed the default as per your convenience, the date of the default.
No, Your Lordship, the very recent default that the corporate debtor has made is the 2020 date. That is why the financial creditor went on with the 2020 date. But since it came under the Section 10A bar, the corporate debtor, that would mean the corporate debtor could get away with by not paying the loan. Therefore, since the existence of the debt has been acknowledged by both the parties and all the records prove the same, another application was filed with the initial date of default as the date of default, Your Lordship.
So the date of default has been changed, right?
Yes, Your Lordship.
Okay. Go ahead.
Counsel, do you not have any other alternative remedy other than the NCLT? Is there no other court that you can approach?
The High Court, Your Lordship, as my
No, no,
co-counsel.
no, no. Where are usually bank cases filed?
DRT, Your Lordship.
DRT, very good. So why don't you approach the DRT, get a judgment from there? Anyway, there's an admission. NCLT is only a summary procedure. You go through the DRT. Why are you coming here? Because you're anyway change your date of default. Go to the DRT under Section 19 RDB Act.
The NCLT and NCLAT proceedings were previously done, Your Lordships,
Correct, correct. I'm
since
saying since you're anyway doing it the second time, instead of going to NCLT and getting this dismissal, we are also not convinced of the case. So you go to the DRT. You can write what
Your Lordship,
there's no requirement of date of default over there. So you can very well argue your case there. Is that not an amicable solution for you?
it is, Your Lordships, but since the IBC provisions were followed and the NCLT was where we have first gone with the proceedings, and then the same was transferred to the appellate authority, and that is why the civil appeal is now before the Supreme Court, Your Lordship.
Okay. So you do not want to use the provisions of Section 19 of the Recovery of Debts Due to Banks and Financial Institutions Act 1993. No?
No, Your Lordship.
Okay. Move on. Proceed.
Much obliged, Your Lordships. Secondly, the incorrect date of default is a curable procedural defect, and which is not a ground for dismissal of application. In the case of Dina Bank versus Shivkumar Reddy
Dana
and
Bank,
another,
the Supreme Court clearly said that there is a right to amend pleadings. Why have you not sought for an amendment? All these case laws, Puneet Patya, Dana Bank, uh, there's an Apple Sponge, all these speaks about amending pleadings, filing additional
yes,
documents. They don't speak of a case where you come to the court with wrong data and then file a second application. All these are on the first application. You didn't amend
yes,
the
Your Lordship.
pleadings, so how is this all applicable to you?
The amendment was not done as the adjudicating authority has not directed the financial credit.
Nobody needs to direct you anything. You should have yourself filed an application for amendment. Why didn't you file? So much public money is involved. Why is the bank taking the case so lightly?
Much obliged, Your Lordships. The bank did not follow the same since before the amendments could be given, the proceedings and the final order was passed. And since it's a very procedural flexibility issue, That is why we are arguing before this honorable court that since it's an incorrect date of default, since it's a since it's a curable procedural default, it shouldn't be a ground for dismissal, Your Lordship.
Curable default before judgment. Once the judgment is passed, you cannot change things. Can you amend pleadings after judgment?
No,
Is
Your
that
Lordship,
no? Am I?
that is
Am,
why it.
Finality has been reached in the judgment by passing a judgment.
Yes, Your Lordship, that is why we did not amend the pleadings and came for a civil appeal in the Supreme Court, Your Lordship.
but you're arguing now only amendment. Dana Bank is about amendment, para 144.
Yes, Your Lordship, I am citing Dana Bank to say that the allowing of filing of additional documents to advance the cause of justice does not hinder a genuine
We
insolvency.
we have no problem in allowing it. We have an issue that you have not written the correct date of default the first time. You didn't amend your date of default before judgment. Now you come the second time with the same case.
Yes, Your Lordship, we did make a mistake with the very first application that we
Go to
have made that
DRT.
we.
Go to DRT. Don't waste here the time.
Yeah, much obliged, Your Lordship.
You have
Take,
easily
take a deep breath and continue. You have time.
Yeah. May I move on with the sub issue, Your Lordship?
Yes, yes. Move on, move on.
Since there was a choice between the DRT and the NCLT, is why the appellants have gone to the NCLT in the very beginning. And since we weren't satisfied with the very judgment of the NCLT and the NCLAT, is why we have come to the Supreme Court, Your Lordship.
Please move on. You can make your arguments. You still have time.
Much obliged, Your Lordship. Similarly, I would like to um, cite the case of Canara Bank versus Vasavi Power Services Limited, where it was held that the amendment of date of default before
You're
final
referring to the
adjudication,
NCLT Amravati judgment or the NCLAT Chennai judgment?
the NCLT judgment, Your Lordship.
This judgment was set aside and overturned by NCLAT Chennai. So, are you aware of that? NCLAT Chennai set aside this order.
Um,
And
Apologies, Your Lordship.
you should rely on case laws which are not overturned. You cannot rely on case laws which are overruled by the court. That amounts to misleading this bench.
Much obliged, Your Lordship. Apologies for that.
people are researching, you'll have to see whether the judgment has been overruled or not, and then you'll have to cite it. If it has overruled, that judgment has no value.
We
That is
understand,
how.
Your Lordship.
Thank you, counsel.
Thank you.
Ma'am, do you need a 30-second break before we start respondent?
Yeah.
Okay. We'll take a minute's break. We can Ma'am, are you there?
Yes, I'm very much here.
Shall we start for the respondent?
Yes.
Yes, speaker one.
Good evening. May it please the bench, the council seeks permission to address the bench as your honor.
I
Yes.
think since we are in the Supreme Court, I think you can give us a little more respect and use your lordship. But since these are all colonial titles, you can say sir and ma'am, no problem.
Uh, shall I proceed with ma'am and sir title as side title? Thank you, sir, and thank you, ma'am. I
You're actually practicing as a lawyer, and when you're actually representing, okay, factually representing Supreme Court, the judges are very, very particular the way you address them. So let that be in your mind. Okay? Here it's okay. But when you're actually a lawyer, full-time lawyer, representing Supreme Court, be very, very careful. Is that clear?
yes, ma'am, it's clear. I'll proceed with the ladyship only.
No, madam here. Bus hai, madam bus hai. Okay.
Okay, ma'am, and okay, madam, and okay, sir. I, along with my co-counsel, appear on the behalf of ex respondent, that is XYZ Private Limited. Before proceeding, the council acknowledges that the jurisdiction of this honorable court. This appeal arises from the concurrent order of NCLT and NCLAT
Please don't go into
rejecting the
facts, directly go on to your issues.
uh, much of yes, sir, much obliged. The issue one, which is whether the second application under the section 7 of the Insolvency and Bankruptcy Code, hereinafter referred as IBC, is barred in law or not. The second application is barred by relitigation and the abuse of process. The
No,
first,
counsel, it is not barred by law because you kindly see your clarification. You have your clarification with you?
just give me a minute, sir.
I will read it for you.
Okay,
Para
sir, thank you.
point 12 of the clarification. You should know all this, but we'll assist you. If the first application filed under Section 7 is dismissed for any reason, either on merits or for a technical error committed by the FC, then is a second application under IBC barred by law. So here, the application was dismissed for what? It was dismissed for Section 10A. But the only question that remains today is what? Is there a default or not? NCLT should have just seen is there a default or not. They didn't see that. They went very in a very hyper technical manner. No, the second application ought to be allowed. It is maintainable.
This particular query of the bench will be answered in the furtherance of the argument. Shall I proceed, sir?
No, first you answer our queries.
Okay, sir. Could you please repeat again, sir?
Oh, that you should have told that you didn't understand. I'll read it again. So point number 12 of clarification states what? It says that if the first application is dismissed for any reason, either on merits or for a technical error. What is the technical error here? Why was the application dismissed? Are you aware? The first time?
Yes.
What was the reason?
Because the date of default was falling within the 10A moratorium period,
What
which
is
was
the
inserted.
moratorium period as per 10A?
It states that no CIRP
From when to
proceeding to
when?
be what, sir?
From when to when was a moratorium
Uh,
period?
I'm not exactly sure about the date. It's from March to the next. It's for 1 year.
Almost 1 year. So they
Yes.
mentioned 1/5/2020. Today you just tell me, is there a default? Yes. Is it within limitation? Yes. What survives? Nothing survives.
Uh, shall I proceed, sir, like with answering your query?
You don't take permissions to answer to my questions. You can answer to
Okay.
all questions. No permissions to be asked. Yes.
Okay, sir. So yes, the contention of the appellant is true that the second application can be filed, but there are certain circumstances and there are certain conditions in which the second application can be filed. The conditions are a second application can only be entertained if the first application was withdrawn with the liberty, and if the
Who
second
says so?
application was
Who has
what,
laid
sir?
down this law?
Uh,
Where are you relying this from?
there is a case, sir.
It starts with
Give me a
R,
second.
Rota something. Is it that?
Just a second, sir. Um, yes, in Rolta versus Veronium Cloud.
Rolta's case is by which court?
It is by NCLT.
NCLT which bench? Mumbai, Chandigarh.
Give me a second, sir.
NCLAT.
NCLT, NCLAT, yes.
Oh, so even
Pardon,
respondents are
sir.
not aware of case laws. Okay. So
Pardon, sir. That
Mm.
was thought
Rolta's
on my part.
judgment, what does it say?
It says that the altering the date of default to avoid the Section 10A is not permissible.
Okay. Okay. Altering date of default. But was that case within limitation in that particular facts of Rolta?
What, sir?
Was in the facts of Rolta, was the case within limitation?
The case was within limitation.
They changed the date of default, right? So NCLAT said they
Yes,
should not change the date of default, right?
yes.
So I'm asking you, was that case within limitation when they changed the default?
What is the limitation?
Uh, as far as I can recall right now, the case was not in the limitation.
What is the limitation period? My fellow judge asked. What is the limitation period?
A limitation period applies
How
to
much?
case
What is the time?
three
1 day?
years.
3 years.
3 years.
Okay.
Three
So in that
years.
Rolta's case, it was barred by limitation.
Yes, sir.
Here it is not
It
barred
was
by
not
limitation.
barred. It was not barred by the limitation. The honorable NCLAT held that the mere altering of the date of default to avoid the Section 10A period is not permissible in the proceedings. It was on res judicata. It was on the principle of res judicata.
Which para of the judgment? Please share screen the judgment. Let us see.
Uh, my researcher will take a minute.
You have to be quick with showing the judgments, the relevant paras. It should be already set and prepared because the total period is just 3 minutes. Within 3 minutes, there's no time. So you should be very.
Pardon, ma'am. I seek pardon.
You should
Uh,
be fast. See, so much.
by then, my researcher is doing that. Can I continue?
Yes, yes, please continue.
Thank you, sir. Am I audible? Hello.
Your
Yes.
audible, your fellow people also are.
Okay. So the first issue is barred by the law as the res judicata, the section 11 of CPC, clearly this particular case clearly attracts the res judicata because there are few essentials to attract the res judicata. Some of which are key: the court deciding the formal matter must have been competent, the formal proceeding must be between the same parties, and the remedy sought should be the same, which clearly applies relying on this thing, it clearly applies to our case as well. Further, I would like to say the thing on the merits which the appellant contended, it in the fact sheet itself mentioned that the uh, the application was dismissed on the merits. The fact sheet itself contains it. So the argument of the
Where is it
appellant
in
from
the
that,
fact sheet that it is admitted, dismissed on merits? Which
I'll
para?
tell you, sir. I'll tell you, sir.
Para 9 of fact sheet. Okay, move on.
Yes, sir. Further, I would like to draw the attention of the honorable bench to the a doctrine of merger, which is applicable in our case. It means that the finality has been achieved, so that it reaffirms the res judicata's argument. Further, the matter the matter attains the finality unless expressly left open, which is there are some cases which says that okay, the bank or the company can refile it if the authority explicitly mentioned it, but it was not done anywhere by the NCLT and honorable NCLAT in the present case. So the changing of the date of default is the changing of the date of default, sorry, my fault. So the first application is barred by the law. The council seeks permission to proceed with the issue 2 if the bench doesn't have any query.
You're
do not
supposed
have
to
any.
answer one question, right, with the case law. You said you will subsequently show it to us. Now you
Oh,
forgot about it.
I'm
Researcher,
so sorry. So sorry. Can you open it?
researchers taking so much of time.
Can you?
I have one question, but these IBC proceedings,
Yes, ma'am.
summary proceedings, so they cannot be. Should there be a finality in the judgments?
Yes, ma'am.
Do they constitute final judgments because these are summary proceedings?
Uh, Ma'am, the nature of the NCLAT or NCLT is quasi-judicial. So certainly the objective and what it aims for is the finality to reduce the burden on the other courts. Uh, the the courts which are in practice from hundreds of years, like to reduce the burden of those courts. So I believe the NCLT and
Is that
NCLAT.
the reason why IBC came to reduce the burden of the other courts? Is that the reason?
Sir, it's a specialized code. It deals with a certain issue, certain area, and certain matters. And for each and everything in our country, we have a specific law. For example, for crimes we have BNS, and for procedures we have CPC and
We
all.
know
So
what all
I
laws are existing. We are asking you, how is IBC a law to reduce burden? I thought it was a law. We thought it is a law to uh, bring a resolution mechanism. Now you're saying it is to reduce pendency of cases. I don't understand your logic. And counsel,
sir,
you did not share case law. You just shared a summary of what you prepared. That is not how case laws are to be shared. You have to share the exact replica of the judgment available online, right? You can write whatever you want in your PDFs. That's not how case laws are shared. Yes, please move on. You are wasting further time.
uh, the council seeks permission to move with the issue 2.
Yes.
The second issue is pertaining whether the mentioning of date of default is mandatory or not. Uh, uh, to start with it, the date of default determines the jurisdictional bar under the 10A. Your sir and madam, section 10A states that no applications shall
But
ever
the
be
provision
filed.
of law is very clear. It says that you have to only see, the court had to only see whether there is default or no. They don't have to see whether date of default is mentioned, not mentioned. All that is irrelevant. Appellants clearly argued that.
Exactly, that is what I'm trying to say, sir.
So there is no
That
need to mention. That's what we are saying. There is no need to mention date of default. That is what was argued. Did you hear the arguments of the appellant?
yes, sir.
Then they argue that there is no need to mention the date of default. They only have to see whether there is a default or not.
I was
Mentioning is irrelevant.
I was just continuing with their argument, like to further reaffirm the same thing.
You also agree that not mentioning is okay.
No, I said the date of default. Uh, just give me a second, sir.
During the time you cough, you want to see the screen and get some answers. Not happening.
No, sir. No, sir.
Take a sip of.
I'm really sick. Like that's why I need water. Like my
Oh, we had another team which was typing questions on ChatGPT,
I'm
what we
so
asked, no? Pause the time, timekeeper, let them drink water. Pause the time for a second. Give them
I'm so sorry.
five seconds, let them drink
It's
water.
just due to weather. I'm
Yes, yes,
my
that's why we're giving you 5 seconds. Please drink water. No problem.
okay. To continue with the issue 2, the date of default is mandatory to mention because it decides so many things in a case. It decides the
Who
limitation.
says that a date of default mentioning of it is mandatory? Who said that?
So Form 1, Part 4, it say
Form 1
it
Part 4 is only a requirement of the application. Where is it saying that the mentioning of it is mandatory? Where is it written? Is there a case law? Is there a law?
Section 10A.
Section 10A is on the point of moratorium, madam. Section 10A has nothing to do with Form 1. NCLT
Uh,
rules speak about Form 1, not Section 10A. Appellant argued that it may be mentioned. May means not mandatory.
but
You're
it
saying
is mandatory. It is
where
mandate.
where is it written?
Uh, as far as my knowledge, it is written must in the Form 1 Part 4, which is a procedure to begin with. And even a little error in a procedure can lead to a very significant
This
consequence.
word must is written where you said? NCLT Form 1, where is it written? That
Part
must.
4.
Part 4 asks for details to be mentioned. It's like an empty form, you have to fill it. I understand. I'm asking you, where is it written that the form must be filled? Is there a word like that?
We have
Sir, can I support it with a case law if you want, if
Yes, yes,
I
yes.
may? In a Kode Boria Srinivas was Krishna enclad judgment, the tribunal categorically held that the date of default must be explicitly mentioned, so the adjudicating authority may assertion the existence of debt and default. This make it mandatory, not optional.
Thank you, counsel.
Thank you.
Now
Thank you,
just
sir. Thank you, ma'am.
just
I now respectfully hand over the issue 3
no,
and
no,
4
we,
with.
we we need just a minute.
Okay.
Madam, we'll just take a minute's break.
Yeah, yeah.
Shall we commence, madam?
Yes.
Am I audible, your lordships?
You're
Yes.
audible, but you're not visible. Could you sit opposite light?
Now, am I visible now, your lordships?
There's a shade. Sit, take the place of your TGA 26 speaker one.
Of you all are sitting together on the floor. That is what I observed.
Yes, ma'am.
So your camera should be focused in such a manner that one person is focused.
Is it okay now?
Sit where your speaker one was sitting. Please come there.
Okay, just a minute, sir.
You can start.
Visible.
Thank you, sir. May it please the Honorable Court that the Council is also appearing on the behalf of respondents in the present matter. The Council, although acknowledges the presence of your Ladyships, but seeks the permission from your Ladyships to address the bench collectively as your Lordships.
Okay. Permitted.
Much obliged, your Lordships. Your Lordship, the Council will be speaking for 15 minutes, in which he'll be dealing with issue 3, which pertains to whether the date of default changes based on the facts or is it to be taken as the date of NPA. And issue 4, which strictly pertains to whether the admission of application despite an error in the date of default is admissible or not. So the Council seeks permission to proceed with the issue
All
3.
permissions granted. Don't waste your time seeking permission. Everything granted.
Much obliged, your Lordships, much obliged. Your Lordships, as so far as issue 3 is concerned, it is most respectfully submitted that the statutory definition of default under section 3.
We know. The appellant also argued on statutory definition. You say, why should it not change? Should it change or should it not change? What is your view?
Your Lordship, the date of default should change based on the
Should change.
facts and circumstances of each and every case.
If you argue the date of default should change, then as per para 4, the table point number 9, the case is within limitation. We have to allow this appeal. Yes?
Your lordship, case is within limitation.
Correct.
There is no contention of the appellant, sorry, the respondent, on the fact that the case is well within the limitation. The council does acknowledges the fact that case is well within the limitation as
So
per
you are
section
saying
8.
there is a default that it is within limitation, but still we should dismiss the appeal. Why?
Yes, your lordship.
Why?
Because your lordship, there are multiple contentions. One of the very contention is that the period of default or the date of default is falling under the non-obstany clause of 10A
No,
period.
no, 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 no. You
Specifically
just
bars.
now you just now told us date of
Yes,
default shifts. So after the OTS letter dated 1st May 2020, there was another letter 1st Jan 2021, right?
your lordship, the action, the or the cause of action that was initiated on the date of default was in the first was in the OTS letter that was sanctioned in on 1/2/2020, and the amount that the corporate debtor.
No, it was not
Yes,
on 1/2/2020. Where are you reading that? Read
uh,
para 8 of your fact sheet. It's 1/5/2020.
your lordship, the date of default is 1/5/2020, but
Ah.
the OTS that was issued was on 1/2/2020.
OTA was not issued on 1/2/2020. OTS was sanctioned by the bank on 1/2/2020. There is a
Yes,
difference. What do you mean by OTS sanction?
OTS sanction simply means that the approval of the OTS from the financial creditor side, your
Correct.
lordship.
So the what? Where is it written that OTS was?
Even if we contend on the fact that the default was 1/5/2020, it still falls under, it is squarely falls under the limitation, it squarely falls under the non-obstany clause that has been put up by section 10A, your
We agree
lordship.
with you. You just now told fact date of default changes with new facts, correct? So
Yes, your lordship.
doesn't the date of default change with each OTS letter?
No, your lordship.
Why?
There is a difference between the change in date of default and there is a difference in change of date. There is a change in a limitation period, your lordship. The new OTS could only sanction or only cause a fresh limitation period, but unless and until it is particularly entertained, your lordship, it does not change the date of default.
So what should the date of default be in this case?
Your lordship, the date of default should be squarely when the OTS was sanctioned and it was not fulfilled. It was not fulfilled by the corporate debtor, your
So
lordships.
then, if you look into that, if we take the date of default as 1/2/2020,
One
then
five
the
twenty, your lordships.
no, it was sanctioned on 1/2/2020, no?
Yes, your lordships.
So if it was 1/2/2020, then limitation period will be how many years? You want to count from 1/2/2023 years?
Pardon, your lordships.
See, you want the date of default. What do you want the date of default? Simple question.
The date of default that we contend on is the same.
What is the date of default?
That was, it is 1/5/2020, your lordships.
But 1/5/2020 is just OTS letter. You only said no, OTS letter cannot extend timeline. It should be the OTS sanction.
Yes, your lordship.
1/5/2020 is OTS is cancelled by the.
Pardon, your lordship. 31st March 2020 should be the date of default. This is what we
31st
contend.
March.
Yes, your lordship. When the corporate debtor failed to when the corporate debtor failed to pay
Okay.
the.
So now you come with a new case. 31st
Your
March
lordship, the
2020. No,
council is not.
listen.
Okay, okay, your
31st March 2020 is the date of default according to you.
yes, your lordship.
Is the case within limitation, the second application?
Yes, your lordship. That's
Then we'll allow the application based
your
on that.
lordship. The council does agree to the fact that limitation is one of the criteria, but it is not the sole criteria. The other if the something, if your lordship, if the date of default is squarely falling under section 10A period, that is specifically prohibited. That's
31st
specifically.
March 2020, is it prohibited in 10A? No.
Yes, your lordships.
From when is 10A applicable?
25 March 2020, your lordships.
25 March 2020.
Yes,
Okay.
but
So
it
that
has
is why
a
you are saying
retrospective
31st March
application.
is by 10. Okay.
Yes, your lordship.
What
It
is the
had a
problem?
retrospective
So
application.
why are you not saying that each OTS letter will change the date of default?
Each OTS letter will not change
Where is
the
it written? You just now told it extends timeline. Is there any case law that it will extend timeline and not change the date of default?
your lordship. There are multiple case laws that says that
बताइए.
but
Multiple तो बहुत है, आप एक तो बताइए.
Your Lordship, Dena Bank versus Shiv Kumar Reddy is one of those case laws, Your
Dana
Lordship.
Bank speaks about amendment of date of default. No, which paragraph talks about it extends timeline and does not change the default? Which para?
uh, Pardon your lordship, then the council might not aware of, is not able to recall a particular date of default, but it is an established fact, your lordships, that the date of default and the occurrence of fresh limitation periods are two different concepts in the IBC, your lordships.
Okay.
This is what council particularly contends upon. And secondly, your lordships, the council for the appellants have already
Go on
stated.
to your next last issue, fourth issue. Your time is running.
Okay, your lordship, as your lordship wish. Your
Court
lordship,
master, how much time is there more?
So they still have 7 minutes.
Okay, you can continue. Your wish. You can continue on issue 3 still.
your lordship, the council would like to move to issue 4, if your lordship says.
7 minutes और है आपकी मर्जी है.
Your lordship, your lordship, the council, co-council has a lot substantive to argue on issue 4, and due to the paucity of time, the council would like to
Yes,
move to
yes.
issue 4.
Continue 4 then.
Thank you, your lordship. Your lordship, the fourth issue pertains whether a case can be admitted if the date default has occurred and the application is well within the limitation despite an error in the date of default. Now, your lordship, talking about specifically about the uh, IBC proceedings, your lordship, yes, it is permitted, but it could not be permitted in this particular case, your lordship.
Why?
And there are multiple factors for this.
Okay.
Firstly, your lordship, the case is not of a minor error in the date of default, rather it is associated with multiple technicalities of the code. Error in date of default is such that permitting it to change in the present scenario alters the nature of the case, and that too, your lordship.
How does it alter the nature of the case? Did you not know your loan account was classified as NPA in 2014? Did you not know that? You
Yes, your
knew.
lord.
All your OTS letters extends the limitation you are continuing to
Yes, your lord.
argue. So then the case is in limitation, there is default. What is the issue then? I
Your
don't
lord.
need to bother about date of default. Khatam.
Your lordship, a special ordinance that was passed due to the COVID-19 pandemic, and your lordship,
We will reckon the date of default as a older date. We will not take the new date. We will take NPA date as a date of default.
your lordship, it's solely on the
Case is within limitation. There is a default. What remains? You have to pay 500 plus crores.
your
You want to
lordship,
run away on technicalities with
your
public
lordship,
money?
your lordship, the council or the corporate debtor never intended to run away. Rather, even when there was
He
multiple
hired
failures,
such good counsels only to run away.
no, your lordships,
Huh?
it is not the case.
They're fighting till the
Moreover, your
Supreme Court.
lordship, moreover, your lordships, what does the term OTS means? It means it is a restructured formula, your lordships. It
No,
is a
OTS means one-time settlement request.
yes, your
OTS
lordship.
is not restructuring. Don't use new terminologies and incorrect terminologies.
Pardon, your lordship. But the main contention that the council wants to present in fourth issue is is with the help of Dena Bank versus Shiv Kumar Reddy, your lordship, which your
Dana
lordships.
Bank clearly says you can allow amendment, you can
Yes,
allow additional
yes,
data.
your lordship.
So allow the application, allow
Yes,
the
your lordship.
appeal.
Please, your lordships, if you let the council, please, your lordship, the council is saying that the amendment to the date of default is allowed as per Dena Bank versus Shiv Kumar Reddy, your lordship. But there is a special case to it, your lordship, that if you permit, your lordship, I would continue with my argument.
I said all permissions granted.
Okay.
Don't waste your time.
Much obliged, your lordship. It becomes quite pertinent to refer to Dena Bank versus Shiv Kumar Reddy, which clearly mentions that there is no bar on pleading in an application under Section 7 or file an additional document under 7. It simply means that applicant were at the full liberty to amend the date of default in Part 4 of the Form 1, but they proceeded with the earlier mentioned the date of default, your lordships. It simply means that, your lordship, the date of default mentioned in Part 4 of Form 1 was not a technical or clerical mistake, your lordship. And when the application was dismissed, they decided to come up with an altered date of default, your lordship. When the first application was dismissed, allowing this appeal in the apex code would be an absolute violation of the procedures of the code, as it has been reiterated time and again by the Honorable Supreme Court and CLAT and NCLT, that the change in default in the second application is majorly impermissible, your lordship. Your
Where did
lordship,
Supreme Court hold that till today? This court never held anything like that. Which
your
judgment?
lordship, Your Lordship, the what Supreme Court and the NCLAT and NCLT has said is, even in the Dena Bank versus
Correct.
Shiv
So what did Supreme Court say? You cannot alter date of default and file another application. Did Supreme Court specifically say this?
Your Lordship, Supreme Court specifically said that the form or the date of default could be changed till or
Correct.
unless and
It
until the
can be
final,
changed.
until and
Where
unless the final
council
orders have
listen,
been passed.
listen to question.
Yes,
You're
your
saying
Lordship.
Supreme Court said that altering it and filing a fresh case the second time is prohibited as per the Supreme Court's order. Where did we pass such a judgment? Where is a judgment to this effect?
Your Lordship, I specifically don't remember a judgment matter. I remember case of the fact, Your Lordship, where
Very,
a
very
change in date.
conveniently you say there are case laws. When we ask which case law, you say I don't remember the case law. Then you say there are many case laws. ये हवा में तुक्का नहीं मार सकते हो सुप्रीम कोर्ट
No,
में.
Your Lordship. No, Your Lordship. I am not trying to baffle. Rather, I am trying to simply put the facts in a simple way, Your Lordship, that the applicants were at the full liberty to amend the date of default, unless and until the final orders were passed. Rather, they decided to proceed with the same facts of the cases, and the appellant council itself has agreed that they wanted to circumvent the 10-A period. That's why they have come up with a new date of default.
They did never said
Your
that.
Lordship, that defeats the whole
The
purpose of.
appellant never argued or never
Yes,
admitted. No, I heard the whole argument. I am
Lordship.
we are the bench. Appellant never said that we want to circumvent the 10A period, so we change the default. कहाँ बोला है?
Your Lordship, they
Council
specifically
1 or
said
Council
that
2?
since the prior mentioning of date of default was falling under 10A, that's why they decided to come up with the.
You say that, but don't say they argued that. They didn't argue that. You say that their intention is that you say makes sense. Don't say
Yes,
they
Your Lordship.
argue when they did not argue. And
Your
don't say
Lordship,
that there is a case law when there is no case law.
sir, Your Lordship, there is, but the council is really not getting into remances, Your Lordships, where there was case law that a change in date of default was where the date of default was tried by the councils for the appellant, but it was vehemently rejected by the Supreme Court, Your Lordship. It's very unfortunate that the council is not able to recall that particular case law, Your Lordships. But
When you speak,
Ne- uh,
speak that Supreme Court has passed such a thing, you have to speak of the proof. Proof is very important. What is the evidence?
Your Lordship, I guess the case law was Ramesh Kaimal versus Siemens Gamsa, Your Lordships, where where your
1 minute, like you have to listen also.
pardon, leaderships.
When without proof you cannot say it. Without proof you cannot talk. So you always have to speak with proof.
Your leadership, the council.
You don't speak about it at all.
Your leadership, the council is citing the case law of Ramesh Kaimal versus Siemens Gamsa, your leaderships.
What does it say?
Your leadership, this says that it was quite categorically held that the wordings of Section 10A, that no application shall ever be filed, shows the core legislative intent of the Act, your leaderships. Section 10 is prefaced with a non-obstaining clause which overrides Section 7, 9, and 10.
Council, what you're arguing is not what the judgment said. The judgment speaks about the aspects of moratorium section 10A. What you argued, amending date of default and filing a second application is barred by law. That is not what Ramesh Simons say.
Your Lordship,
No. This is not how you say. And this is not a Supreme Court judgment. This is an NCLT Chennai bench judgment, right?
no, Your Lordship.
Seaman Gamesha Renewable Power versus Ramesh Kaimal. Isn't this an NCLT bench judgment of Chennai?
No, Your Lordship, the citations, pardon, Your Lordships.
Is this Ramesh Kaimal versus Seaman Gamesha?
Yes, Your Lordship.
This is Supreme Court only based on Section 10A. It is not relating to what you're saying. You're continuously misleading the court counsel. Not happy.
Your
Anyway,
Lordship,
time up. Thank you.
Pardon, Your Lordship. 1 minute to conclude.
No. No extensions to anybody.
Your Lordship,
Thank you,
two
counsel.
different cases was. One was Dina Bank versus Shiv Kumar Reddy, and
Counsel,
another.
thank you.
Thank you, Your Lordship. It was pleasure to argue for Your Lordships.
Are you sure?
Yes, Your Lordship, completely sure.